Welcome to the Am I Free to Go podcast, where the Constitution isn't just paper, it's ammo. I'm your host, Soundrone with Soundbite News Media. And here, we don't just talk about your rights, we lock, load, and defend them. We expose censorship, spotlight real amendment battles, and bring you the stories the mainstream's too scared to touch. So, whether you're behind a mic, behind a badge, or behind enemy lines on social media, this is your front line in the fight for free speech. Strap in, speak up, and never ask permission, because around here, we know the truth. You are free to go. Episode number 010, Police Misconduct and Color of Law, is about when someone with a badge uses their authority to break the law. That's called acting under color of law, and it's actually a federal crime, no matter how confident they looked doing it. We'll explain how to recognize it and what the law says about it. Just because they're in uniform doesn't mean they're untouchable. All today on the Am I Free to Go podcast.
Ever wonder how you hold someone in power accountable if they step on your constitutional rights? Like, you have these fundamental rights, they're guaranteed on paper, right?
Yeah.
But what actually happens when the person sworn to uphold the law is, the one breaking it.
Yeah, it's really the absolute core of what makes a government of laws, well, what it is. Chief Justice John Marshall put it famously way back in Marbury v. Madison.
Right.
He said the U.S. is a government of laws and not of men. And he didn't mince words, adding that it would certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right.
Exactly. It's like James Madison called rights without remedies just parchment barriers.
Parchment barriers, yeah.
They look nice, but they don't do anything if you can't actually enforce them.
And that's precisely what our sources are digging into today. They walk us through the legal tools we have here in the U.S. that are specifically designed to, tackle this exact problem.
Holding government officials accountable.
Right, when their actions violate constitutional rights. We're going to get into U.S. Code Title 42, Section 1983, and Title 18, Section 242, and also some really critical legal doctrines that have shaped how effective these laws actually are, in the real world.
And honestly, it gets really interesting and, sometimes, as the sources show, maybe a little frustrating when you see how these laws actually play out.
Definitely.
We're going to uncover why achieving that accountability can be, surprisingly difficult, and look at different perspectives the sources offer on how the system works now and how some argue it could be reformed.
So let's start. The main tool, the one you often hear about for state and local officials, that's 42 U.S.C. Section 1983.
Okay, Section 1983. This goes way back, right? Congress enacted it in 1871.
That's right, Reconstruction era.
The whole point was to give individuals a way to enforce their newly guaranteed rights against state and local government actors who might be violating them.
And the language itself, it's incredibly broad, really powerful. It says, every person who, under color of any statute, ordinance, regulation, custom, or usage of any state, subjects, any citizen, to the deprivation of any rights, secured by the Constitution and laws, shall be liable to the party injured in an action at law.
Wow, okay. So the basic idea seems pretty straightforward.
Yeah.
If an official acting in their job capacity violates your constitutional rights, you have a right to sue them for damages. The sources really hit this core purpose, giving a remedy to victims, and, the threat of being sued hopefully makes officials respect those rights.
That's absolutely the intention. But here's where our deep dive gets a bit more complicated.
Okay.
Our sources really highlight how, despite that clear aim and that broad language, Supreme Court doctrines have, significantly limited how far Section 1983 actually reaches, especially for state and local officials.
And the two big ones are?
Qualified immunity and absolute prosecutorial immunity.
Qualified immunity. Feels like that's the one everyone's talking about lately.
It gets a lot of attention, yeah.
And one of the most surprising things from the sources is that Section 1983 itself, it doesn't even mention qualified immunity, does it?
Not at all. It's not in the text. And historically, under common law, you could generally sue officials who acted unlawfully.
Right.
So qualified immunity, it's a doctrine the courts created. It acts like a shield, basically.
Protecting state and local officials.
Exactly. Protecting them from civil lawsuits under Section 1983, even if they did violate someone's rights, as long as their actions didn't violate what the court calls clearly established law at that specific time.
Okay, clearly established law. This is where it gets really tricky for someone trying to sue, right?
Very tricky.
Because the courts haven't just said, oh, you need a clear legal rule. They've tightened that standard like crazy.
Yeah.
They now say clearly established law must be particularized to the facts of the case.
And what that actually means in practice, as one source explains it, just knowing you have a general constitutional right, say freedom from excessive force, isn't enough. No. You often have to find a prior court case with facts that are, well, functionally identical or incredibly similar to your situation. The standard, and this is a quote from a source, requires that existing precedent must have placed the statutory or constitutional question beyond debate.
Beyond debate. That sounds like a really high bar.
It is. It's a very high bar.
Okay, let's make this concrete. The source has had some examples, right?
Right.
Like that case, Baxter v. Bracey.
Ah, yes. The police dog case.
Right. So officers used a police dog on a suspect who had clearly surrendered. He was sitting down, hands up.
Okay.
Now, there was a prior case saying it was unlawful to use a dog without warning on a suspect lying on the ground, hands at their sides.
Right. Seems relevant.
But the court granted qualified immunity anyway.
And why?
Because the prior case involved someone lying down, not sitting up with hands raised.
Seriously, that specific posture difference?
Yeah. The court said they needed a case specifically showing it was clearly established that using a dog on someone sitting with hands up was unlawful. That sort of tiny factual difference was enough.
Wow. Okay. That feels, counterintuitive.
Totally. And there's another stark example from the sources, Lateith v. Phillips.
The car chase one.
Yeah. An officer rammed a car, it crashed, then he shot the driver multiple times, killed him. Now, prior cases had established that shooting a fleeing driver from the side is unlawful if they don't pose more than, like, a fleeting threat.
Okay, so you'd think that principle applies here.
You would. But the court majority granted immunity again. They said the prior cases were distinguishable.
Distinguishable how?
Because those cases involved officers confronting a car that was just starting to flee. Lateith's, on the other hand, was shot after a multi-minute car chase.
So the length of the chase made the difference in whether the shooting violated clearly established law.
Apparently so. And the dissenting judge in Lateith's really nailed the frustration, saying the level of factual similarity the court demands is, quote, probably impossible for any plaintiff to meet.
Wow. That quote really gets at a key criticism you see in the sources. This standard creates a, what they call a perverse effect.
How so?
Well, it can actually be harder to sue for really awful, maybe unique misconduct, precisely because it's so bad or unusual that it hasn't happened in exactly the same way before.
So there's no prior case with those near identical facts.
Exactly, no clearly established law for that specific scenario.
There was that quote from a federal judge in one source. Pretty blunt.
Oh, yeah.
Said qualified immunity smacks of unqualified impunity, letting public officials duck consequences for bad behavior.
Yeah.
As long as they were the first to behave badly.
Unqualified impunity, that's strong.
And the sources pile on more examples. Corbett v. Vickers, officer shoots at a dog near kids, hits a 10-year-old child by mistake.
Oh my gosh.
Immunity granted. Why? No prior case involved those unique facts.
Shooting a dog near kids and hitting a child. Unique facts.
Okay.
Or Kelsey v. Ernst.
Officer uses a blind body slam on a woman who was just walking away after being told to stop. Breaks her collarbone. Immunity granted. Because no prior case specifically forbade a takedown on someone walking away after being told to get back here.
It just seems like these really fine distinctions are letting violations slide.
It does feel that way based on these examples. So one source suggests a pretty direct fix from Congress.
What's the idea?
Amend Section 1983, just explicitly state that needing clearly established law or the official believing their conduct was lawful is not a defense, period.
Just get rid of that requirement.
Oh, yeah. And they also tackle that common argument you hear against getting rid of qualified immunity.
The whole split-second decisions thing, protecting police discretion.
Exactly. The sources argue that fear is, well, maybe overblown.
Why is that?
Because the standard for judging things like police use of force, the Fourth Amendment standard, already takes that into account.
Ah, the objective reasonableness standard.
Right. It asks whether the officer's actions were reasonable from the perspective of an officer on the scene at that moment, given the circumstances. It already builds in room for reasonable mistakes in high-pressure situations.
Okay, so if an officer makes a genuinely reasonable mistake under pressure, their action might not even be a constitutional violation in the first place.
Precisely. Qualified immunity only becomes relevant after a court has already decided a constitutional violation did happen.
So the argument is you don't need this extra layer of immunity on top of the reasonableness standard that's already built into the constitutional right itself.
Yeah, the sources suggest maybe some clarifying statutory language about objective reasonableness could work without needing qualified immunity as this extra shield.
Interesting. Okay, so that's qualified immunity. Huge hurdle. But you mentioned another one, absolute prosecutorial immunity.
Right. This is different. Also created by the Supreme Court, not in the statute.
And it applies specifically to prosecutors.
For actions they take in the judicial phase of the criminal process. And again, the sources argue this just isn't supported by the text or history of Section 1983.
The key case people point to is Imbler v. Patman from 1976.
Right. And the court's reasoning was based on, a perceived common law immunity that judges and grand jurors had.
But the counterargument you see in the sources is, well, historically, back in 1871, when Section 1983 was passed, there wasn't really this specific concept of prosecutorial immunity. Most of what prosecutors did back then was seen as quasi-judicial, more about, policy discretion investigations, not actual judging in court. And those kinds of roles didn't typically get absolute immunity under 19th century common law.
Okay, so the historical basis is debated. What's the practical impact today?
It's pretty huge. Prosecutors are completely shielded from civil suits under Section 1983 for misconduct related to, say, initiating charges or handling a criminal case.
No matter how bad it was.
No matter how intentional, malicious, or how devastating the consequences were for the person wrongly targeted. Absolute immunity.
Wow. The case of Michael Morton, that was in one source, right? That really hits home.
Yeah, just a heartbreaking story. He spent 25 years. 25 years in prison for a murder he didn't commit.
And the prosecutor, Ken Anderson.
Intentionally hid evidence. Evidence that would have cleared Morton.
So what happened to Anderson?
Well, he eventually faced a criminal contempt charge. He pleaded guilty, served 5 days in jail.
5 days? For hiding evidence that cost someone 25 years?
Yep. And because of absolute prosecutorial immunity, Michael Morton, the man who lost decades of his life, he had no way to sue Anderson civilly for that misconduct. No civil remedy against the prosecutor himself.
It just seems fundamentally wrong.
It's a really stark example of how this doctrine can leave a victim completely without a civil path to justice, even when there's clear intentional wrongdoing by a very powerful official.
So what are the proposed fixes here?
Well, similar to qualified immunity, some sources suggest Congress should step in. Clarify Section 1983 to say that acting as a prosecutor isn't a defense. Or maybe a less drastic step, at least get rid of the immunity if a court has already formally found that the prosecutor engaged in misconduct.
Okay, so we've got individual officials, qualified immunity, absolute immunity. What about their employers, the cities, the counties? Can you sit them under Section 1983?
You can, yes, but there's another twist here.
Of course there is.
So at common law, there was this idea called respondent superior. Basically, the boss is responsible for what the employee does on the job.
Makes sense. Like if a delivery driver crashes the company truck, you sue the company.
Right. But the Supreme Court, in a case called Monell v. Department of Social Services, said that doesn't fully apply to Section 1983.
How so?
Well, Monell said municipalities, cities, counties are persons that can be sued under Section 1983. That was big. But you can only sue them if the constitutional violation was caused by an official policy or custom of the municipality.
So it's not enough that their employee violated your right.
Nope. You have to link it back to some kind of official policy or a widespread practice that's basically become custom, even if it's not written down. You can't just sue the city because one officer messed up unless that mess up reflects a broader policy or custom.
That sounds like another really hard thing to prove.
It definitely can be. And this is another place where sources argue for Congress to change the law.
What's the proposal?
Amend Section 1983 to create direct employer liability. So, if an employee violates someone's constitutional rights while on the job, the employer, the city, the county, is automatically liable. just like in that common law respondent superior idea. No need to prove a separate policy or custom.
And the argument is this fits better with the original intent.
Yeah, they argue it aligns better with that older common law principle and probably what the Reconstruction Congress was thinking.
Okay, and why is holding the employer liable seen as so important? Two main reasons, right?
Right. First, it gives the victim a much better shot at actually getting a full remedy, getting compensated for the harm.
Because the city has deeper pockets than the individual officer.
Exactly. The employers generally have the funds.
Right.
One source had this wild statistic that 99.98% of the money paid out in lawsuits against individual officers is actually paid by their employers or insurers, not the officers themselves.
Wow. Almost all of it.
So making employer liability automatic just ensures that the entity that usually ends up paying anyway is formally on the hook, guaranteeing a path for relief.
Okay, so better remedy for the victim. What's the second reason?
Incentives. It creates a really powerful financial incentive for those government bodies, the cities, the police departments, to actually improve their systems.
Like better hiring, better training, better supervision.
Precisely. To prevent misconduct from happening in the first place because they know they'll be paying the price if it does.
Makes sense. Now, the sources talked about shared liability, not just making the employer liable.
Yeah, they advocate for what's called joint and several liability, meaning both the employer and the individual employee could be held responsible together.
Why not just put it all on the employer?
The argument is about balance. You get the victim remedy and the employer incentive, but the individual officer still has, as one source put it, some skin in the game.
As opposed to no skin in the game if only the city pays. Keep some individual accountability or deterrence factor.
That seems to be the idea. The suggested statutory language would just make the public employer jointly and severally liable for the employee's constitutional violation, getting rid of that Monell policy or custom hurdle.
And this shared approach allows for some flexibility, right? Like that Colorado example.
Exactly. Colorado reformed its state law on qualified immunity, and their system now generally has the employer pay the full judgment. That's called indemnification. But the officer can be personally on the hook for a small part of it, like 5%, or up to a $25,000 cap, if the department conducts an internal review and finds the officer's conduct wasn't in good faith or wasn't based on a reasonable belief it was lawful.
Interesting. So it ties the personal liability to an internal finding of bad faith.
Right. It shows how a shared system can be designed with nuances, maybe encouraging better internal reviews and accountability, allows states and cities to experiment, maybe even use liability insurance for officers for that smaller portion.
Okay, that covers Section 1983. Pretty thoroughly state, local, individual officers, employers, immunity. What about federal officials? If an FBI agent or, I don't know, an IRS agent violates your rights?
Yeah, that's a different pathway. Historically, you could sometimes sue federal officials personally under common law.
How did that work with sovereign immunity, the idea you can't sue the government?
Well, the legal thinking was if the official acted beyond their legal authority, like violating the Constitution, then they weren't really acting as the government anymore. They were acting on their own. So sovereign immunity didn't shield them personally from a common lawsuit like trespass.
Like that old English case that the sources mentioned, Carrington v. Entick. Officials broke into a house with a bogus warrant.
Exactly. They got sued for trespass, personally. But the problem was, common law torts like trespass didn't always cover newer kinds of constitutional violations.
Like wiretapping.
Right. Maybe a Fourth Amendment violation, but no physical trespass you could sue for under old property law.
So the common law didn't quite keep up.
It didn't, which led the Supreme Court in 1971 in Bivens v. 6 unknown named agents.
Bivens, heard of that.
To basically create a direct right for individuals to sue federal officials for damages for violating their constitutional rights. Kind of like Section 1983, but court created for federal officers.
Okay, so there's a way, but I'm sensing a but.
There's a big but. Bivens' actions have become incredibly difficult to actually win.
Why? Same reasons as 1983.
Pretty much. Qualified immunity is a huge roadblock for federal officials sued under Bivens, just like for state officials under 1983.
How huge?
Well, one source cited an analysis looking at Bivens' claims from 1971 to 1985. They looked at roughly 12,000 claims and found only 5 successful recoveries. 5 out of 12,000.
Wow. That's not a great success rate.
Not at all. It's pretty striking. So a key argument you see from the sources is that this court-created Bivens remedy just isn't cutting it.
So what's the alternative?
They argue it should be replaced by Congress with a proper law, a statutory cause of action against federal officials, kind of mirroring the proposed reforms for Section 1983, meaning it would include that shared liability idea with the federal government as the employer, and crucially, it would explicitly get rid of the qualified immunity defense for federal officials too.
Okay, so create a federal equivalent of a reformed Section 1983.
That's the idea put forward.
All right. So far, we've been talking mostly about civil remedies, right? Individuals suing officials for money damages under 1983 or Bivens.
Correct.
But there's also a criminal side to accountability, where the government itself goes after the official.
Yes, absolutely. That's primarily where 18 U.S.C. Section 242 comes into play.
Section 242.
This law makes it a federal crime for someone acting under color of law to willfully violate a person's federally protected rights.
Okay, so this isn't something a victim sues under themselves.
No, it's not a private right to sue. Victims or others report potential violations maybe to the FBI, maybe to a U.S. Attorney's Office, and then the Department of Justice, the DOJ, decides whether to investigate and bring criminal charges.
Got it. And this law also has history.
Deep roots. It originally came from the Civil Rights Act of 1866, then got expanded. The core idea is prohibiting officials acting under color of law from willfully subjecting someone to the deprivation of rights secured by the Constitution or federal laws, or subjecting them to different punishments because of race, color, or alien status.
Okay, that phrase again, under color of law. What does that mean in this criminal context?
It's pretty similar to the civil context. It means acting with authority derived from a government position acting under the pretense of law, using the power of the office even if the specific act they committed was actually illegal under state law.
Like that Screws case the sources talked about. Screws v. United States, 1945.
Exactly. That's a classic, really important case for understanding Section 242.